Welcome back to the Deep Dive. We're here to give you that shortcut to being well-informed. We take the source material, unpack it, and pull out the key insights. Now, this particular deep dive is part of our ongoing series looking into the Manual of Patent Examining Procedure, the MPEP. It's really the operating manual for the U.S. patent system. Today, we're digging into Chapter 700, Examination of Applications, and more specifically, we're focusing right in on Section 701.
Right. 701, our sources frame this as sort of the legal bedrock. It spells out why and how the USPTO has the authority to examine patent applications in the first place.
Exactly. So our mission here is to get a handle on that statutory authority, understand where it comes from based on the material we've got. Okay, let's unpack this. Oh, and before we dive in, big thank you to Mike Shepard. He's the creative director who's put this whole audio series together. Really appreciate it.
Definitely.
And just the usual quick reminder.
Yeah.
This is an AI-generated summary we're discussing. It's purely for education, general info. It is not legal advice.
Always go to the official MPEP or talk to a registered patent practitioner for the real deal.
Okay, so MPEP Section 701, the very first thing, the absolute core principle, is that patent applications have to be examined. The law says so.
That's it. 35 U.S.C. Section 131. It's right there in the statute. The director shall cause an examination. It's not an option.
And the whole point of this examination is
to figure out if the application, and crucially, the invention being claimed, actually meets all the legal requirements to get a patent. If it does, the law says a patent must be granted.
And it's not just a quick look-see. The examination follows specific laws, right?
Right.
The sources mention several key ones.
Exactly. These are the pillars, you could say. First, there's 35 U.S.C. Section 101 that asks, is this the kind of thing that can even be patented? A process, machine, composition of matter? Is it eligible subject matter?
Okay, eligibility first, then.
Then you hit Section 102, novelty. Is it actually new? Has someone else already done this exact same thing?
And Section 103. That's the obviousness one.
Right. Is it more than just an obvious tweak on what's already out there? Would someone skilled in that particular field find it obvious?
Makes sense. And there was one more major one mentioned, Section 112.
Yes, Section 112 is critical. It's about the application itself. Did you describe your invention clearly enough so someone else could make and use it? That's enablement. Does the description support what you're claiming? And are your claims clear? Do they define the boundaries properly?
So eligibility, novelty, non-obviousness, and adequate description in claims. Those are the big legal hurdles.
Those are the core substantive requirements the examination hinges on.
The sources also flag 35 U.S.C. Section 100, the definitions section. Why is that important here?
Well, definitions might sound dry, but they underpin everything. What legally counts as an invention or a process, the statute defines these.
Okay.
And a really key one mentioned is effective filing date in Section 100. Especially now, under the first inventor to file system, that date is everything. It determines what prior art counts against you for Section 102 and Section 103.
Got it. So that definition directly impacts whether you meet those novelty and non-obviousness tests.
Absolutely.
Okay, so here's where it gets really interesting for me. This core mandate in Section 131, examine the application against these legal pillars. It seems to branch out into this huge, detailed framework covering everything about the application process.
It really does. The examiner's authority stemming from that statute isn't just about judging the invention in isolation. It's about making sure the entire application package complies with the whole network of laws and regulations.
So you mean like checking who's actually filing the application, not just what they file?
Exactly that.
Yeah.
The sources point to rules about identifying the inventors correctly. That's a legal requirement, even in provisional applications. And there are specific procedures, like if you need to correct the listed inventors later on, that's covered, and it ties back to other statutes.
And ownership comes into play, too. What if the inventor sold the rights?
Yep, that's covered. Rules for applications filed by assignees, the company or person who bought the invention. The sources mention needing to record that assignment officially with the USPTO.
Why?
Well, the office needs to know who has the legal right to actually pursue the application, make decisions, pay fees. You have to establish that ownership to take action. It ensures the right party is involved.
Okay, that makes sense. What about lawyers or agents, patent attorneys?
Representation is another piece. Who has the power of attorney to act for the applicant? The framework specifies this, outlines the role of registered practitioners, and it connects to practical things like where the office sends correspondence, getting the address right, making sure communications are secure, even down to rules about using electronic signatures like S-signatures. It's all part of ensuring a legally sound process.
Wow, okay, so the legal authority really covers the whole administrative side too, not just the technical invention part.
It has to. Think of it like this. The statute mandates a complete examination, and that includes verifying all the inputs are correct. This extends to how applications relate to each other, too.
You mean like claiming priority to an earlier filing?
Exactly. If you want the benefit of an earlier U.S. filing date or priority from a foreign application, there are very specific statutory hoops you have to jump through. 35 U.S.C. 119, 120, those kinds of statutes.
And the sources kept mentioning the application data sheet, the ADS, for this.
Yes, often that's where you formally make those claims. It's a procedural requirement, but getting it wrong has huge substantive consequences.
How so?
If you mess up the priority claim, you might lose that earlier effective filing date we talked about. Suddenly, more prior art might apply, and your invention might not be patentable under Section 102 or 103 anymore. It directly flows from not meeting those formal rules.
Okay, so we've got rules about who files and how applications connect. What about the content inside the application itself? The sources stress the examiner has authority there too.
Absolutely fundamental. This ties straight back into Section 112, the disclosure requirement. Is the specification complete? Are the claims there? Do the drawings meet the rule?
Rules for drawings, like what?
Oh, yeah, specific formatting rules, like margins, line types, and the sources even mention when you can use color drawings or photos, particularly for design patents. It's all prescribed.
And inventors have to submit an oath or declaration that's legally required.
Yes, based on 35 U.S.C. 115. They have to swear, essentially, that they believe they are the true inventor and that the invention is patentable. Or there are substitute statements allowed in certain cases.
And fees, of course.
Yeah.
Can't forget the fees.
Definitely not. Paying the required fees, filing fee, search fee, examination fee, maybe size fees if it's a long application that's part of having a complete application ready for examination. No fees, no examination.
The sources also went into a lot of detail on sequence listings. That sounds pretty specific.
It is, and it's a perfect example of how that core requirement in Section 112 for complete disclosure triggers very detailed regulations. If your invention involves DNA, RNA, or amino acid sequences,
Like in biotech.
exactly, you have to provide those sequences in a very specific electronic format, and those rules just changed significantly.
The new XML format, right? WIPO-ST26.
That's the one. For applications filed on or after July 1st, 2022, you must use that format and follow the related U.S. rules. Before that, it was different formats, like ASCII text files.
Wow.
And the rules cover how you amend them, how you incorporate them by reference. It gets incredibly granular. But it all stems from that legal need under Section 112 to ensure the invention is fully disclosed and accessible. And what's really fascinating here, seeing how these tiny details, the exact format for an amino acid sequence or the specific rule for recording an assignment, they aren't just random bureaucratic hoops. They're direct consequences of that bigger legal mandate from Section 131. The USPTO must conduct a thorough examination based on the law. It's like you said, it's not just a blueprint. It's more like the entire legal operating system for patents, making sure everything is verifiable, clear, legally sound.
Right, and that operating system fundamentally dictates how the invention itself is judged against those core standards we started with, 101, 102, 103, 112.
Using prior art, checking what came before under Section 102 and Section 103, the sources highlighted how the legal framework defines what counts as prior art.
And how it changed with the America Invents Act, the AIA. The rules for prior art before the AIA are different from the rules now under the first inventor to file system. The sources mention specific subsections like pre-AIA 102E versus AIA 102A2.
And exceptions, too, like if it was the inventor's own earlier disclosure.
Yes, the AIA introduced specific exceptions under 102B for the inventor's own work published within a year before filing. That's part of the legal framework examiners apply.
And for non-obviousness, Section 103. The legal standard there requires the examiner to explain why it would have been obvious. They have to provide a rationale, especially if they combine multiple references. The sources even point to landmark court cases like KSR v. Teleflex, which shapes how examiners legally approach that obviousness analysis.
Okay. And Section 112, again, beyond just having a description, the sources mention legal concepts like written description support and enablement.
Crucial concepts. The law, interpreted by courts, requires that your written text provides adequate support for everything you're claiming. You can't claim more than you've actually described. Cases like Amgen really drive this home.
And enablement.
Enablement means your application has to teach someone skilled in the field how to actually make and use the full scope of what you're claiming without needing excessive experimentation. It's a high bar. And Section 112 also has specific rules for certain claim types, like means plus function claims, dictating how they're legally interpreted based on the structures disclosed in the specification. Again, court cases often clarify these legal standards.
So the examiner's authority, grounded in statute, extends to these very nuanced legal interpretations. It also covers procedural things during the back and forth.
Oh, definitely. Take restriction requirements. If your application claims, say, 5 different inventions.
The examiner can make you pick one.
Essentially, yes. The law allows the examiner to require you to restrict the application to a single invention for examination in that filing. You can file separate applications called divisionals for the others. It's about managing the examination workload efficiently, and it has a specific legal basis in the MPP.
What about double patenting? I saw that mentioned.
Another key legal check. Examiners have the authority and duty to reject claims if they cover the same invention or an obvious variation already claimed in another patent or application by the same owner.
Can you fix that?
Sometimes. For the non-statutory type of double patenting, the obviousness type, you can often file something called a terminal disclaimer. This legally ties the expiration date of the second patent to the first one, preventing an improper extension of the patent term. Again, specific rules govern this. Honestly, the legal authority stemming from Section 131 touches almost everything the office does: how they handle mail, how they classify applications for searching, the search itself when applications get published, even sensitive things like secrecy orders for national security reasons under 35 U.S.C. 181.
Different people in the office handle different parts.
Right. Authorities delegated, certain officials handle petitions if you disagree with a procedural decision, for example. It's
Right.
all part of this structured legal authority.
Okay, bringing it all together, what does all this mean for you, the listener, whether you're deep in the patent world or just curious about it?
Well, if we connect this back, the big takeaway is that the patent examination process isn't just a set of arbitrary bureaucratic steps. It's grounded in specific laws passed by Congress.
Right.
These statutes and the detailed rules flowing from them create the entire framework for defining what an invention is, who owns it, and what rights come with a patent. It aims for clarity, predictability, and ultimately, that constitutional goal of promoting innovation by granting rights in exchange for disclosure.
And understanding this framework is important because, as the sources really hammered home, not following these rules can cause real problems.
Big problems. Like we said, getting a priority claim wrong could invalidate your patent years later. Missing a deadline for responding to the examiner could affect your patent's lifespan through patent term adjustment. Compliance isn't just about paperwork. It's about securing and maintaining valid legal rights, which naturally raises a pretty big question. How on earth does anyone keep track of all this? It's a massive interconnected system.
It really is complex, no doubt about that. So let's recap. We dove into MPP Section 701 and found that the simple-sounding mandate in 35 U.S.C. Section 131 that applications must be examined is the source of this incredibly broad and deep legal authority.
An authority built on pillars like Section 101 for eligibility, Section 102 for novelty, Section 103 for non-obviousness, and Section 112 for disclosure. And this authority extends to regulate everything who applies: the content, the fees, the procedures, the prior art analysis, even post-grant implications.
Yeah, we just scratched the surface with examples drawn from all over the MP, but hopefully you get a better sense of the strong legal foundation underpinning every examiner decision.
And knowing this exists, even at a high level, gives valuable context for anyone dealing with the patent system. It shows how those big legal principles translate into very specific practical rules.
Definitely.
So maybe a final thought for you to chew on. Next time you encounter a very specific patent rule, maybe it's about sequence listing formats, maybe it's about how assignees prove ownership, maybe it's about drawing margins pause, and consider how that seemingly small detail ultimately traces its authority all the way back to that fundamental command in 35 U.S.C. Section 131 that applications shall be examined according to law.
It really connects the micro details to the macro purpose. A powerful link. Okay, and our final reminder. Educational discussion only, not legal advice. Please consult official sources or professional. That wraps up this deep dive. Thanks for joining us.